Yeah, good morning. You are welcome. This session of this side event, organized by the Global Alliance for the Defense of Youths and Less Privileged, and OVOM and Drug-Free Australia. And we also welcome those who are joining online. Our focus today is the rights of children compatible with the clamor for the rights to use illicit drugs. Because for quite a while now, there's so much clamor on the right of individual who wants to use drugs, and we have to now ask ourselves. Every country is asked to protect the child. So let's juxtapose that clamor with the rights of the child. My name is Eze Luche. I'm the head of the legal team of One Voice, One Message, teaching One Voice, One Message, and I'm the president of the African Center for Health, Law, and Development. That's me. Okay.
Is it maybe again?
Yes, sir. Sure. Okay. Just put it on.
Yeah. Oh, that's a bit helping.
I can pick.
Okay. Okay. So I have to put the overview of this presentation. Just put it up. Yeah, we'll talk about the foundational human rights principles, what the base of human rights issues, and then the background to and the state of illicit drug users' rights. Third, we'll also talk about the background to and the state of children's rights. And then we're also going to talk of areas of compatibility and which takes priority, and then we'll make conclusions. By the way, there will be other speakers here, who will take other aspects of the discussion. The foundational precepts. Now, this is precept, not the principles. If we understand human rights has a very long history, and I'm just going to take us slightly through the process. We know what before it was just to avoid the rights of might, so that we don't become like a brutish society where anybody who has power takes whatever he wants. So human's nature codified human rights over time. We started the Magna Carta with the Code of Hammurabi, the Cyprus sealing them. But for modern era, the codification of human rights started with, let's say, the UDHR, that's the Universal Declaration of Human Rights, where the entire United Nations came together and said, okay, in acknowledgement of humanity, these are the basic rights which everybody should have and should be protected with. We also have the ICC, International Convention on the Civil and People's Rights of 1966. Now, the foundational precepts, this is not conclusive, but every human being is deemed to have the right to life, the right to liberty, and the security of the person. These are basic fundamental rights. But we should also realize that human rights law was developed to protect human dignity and not to constitutionalize every claim of personal preference. That we must, in all we do, we must realize this, because even the UDHR came into being when the world saw what happened to the Jews during the Holocaust, and there was a felt necessity to protect the human being, the human nature, the humanity, and not to constitutionalize every claim of personal preference. Otherwise, someone will say, I have a right to break your head. I have a personal preference to hit you. So the concept of human rights is not to constitutionalize every claim of personal preference. If we agree with that foundational, then we cannot proceed. Because otherwise, we find ourselves going back to the brutish era where someone will come and claim a right, and because of that right, he will try to supersede the societal or communal rights. So we must always have that line at the back of our mind that human rights law was developed to protect human dignity and not to constitutionalize every claim of personal preference. Now, the background to the state of illicit drug users' rights. When did all this come about? It is championed by activists. We must realize that, not by state actors, not by state parties. The state parties, the global level, had the 3 international drug conventions. This is what the governments want. This is what the individual, the state society wants. Now, activist elements now decide, okay, let us champion this. Let us find a crack in the human rights wall and try to push through individual preferences. And they are supported by profit-motivated corporate entities whose prior motive or whose sole motive really is profiteering. We must have this in the back of our mind. It is not the state, it is not we the people, it is rather profit-oriented entities who come together and say, okay, let us see how we can make some money from all this process of prioritizing the right of the individual to use drugs. And some of these activists include Timothy Leary, a British fellow who campaigned for LSD to be legalized. And then we also have the Shaffer Commission. We try to legalize cannabis, and some states in the US have now legalized cannabis. I'm just trying to trace the origin of the right. Now, you realize that it began from activist elements, not state parties, not the society. It was people who felt they needed to profit from the whole drug scenario. And it has crystallized into, like, it's now a global issue with the international guidelines on human rights and drug policy. We will have other speakers who will address the faults of these so-called international guidelines on human rights and drug policy. Because like the whole idea about championing the rights of the drug user, these guidelines was also set up, was also created or crafted by individuals who want to profit from the illicit drug business. We must realize that there is no global treaty, there is no global covenant, there is no convention or agreement backing these so-called rights up. There's none whatsoever. The international guidelines is actually a fraud. You hear from the, we have a researcher who has done a lot of research on that. You hear how fraudulent that document is. Now, background to and state of the children's rights. I've given you the how the whole so-called the hocus pocus about the users' rights are. Now, for the children's rights, the most signed global convention is the Convention on the Rights of the Child. That more state parties, over 193.
To 96.
Good, 196, he says now, have ratified that convention. So it's a we affair, it's a global affair. State parties have signed it, and it draws some support from the UDHR, from the Universal Declaration on Human Rights, and the ICCPR. They all focus on the rights of the child. So we now notice the difference. Illicit drug users' rights has no basis in international law, no basis in even national laws. It's just a configuration of some activist elements. But we are now talking about the child's rights. Countries have said, okay, we want to protect our children, we want to take care of our children, and that is what we're not comparing. Illicit, illegal acts and state-supported acts. The background to the state of children's rights, I will cite some sections of relevant laws. The Article 6.2 says that states must ensure that the maximum extent possible, the survival and development of the child. That is CRC, Convention on the Rights of the Child. It goes to deep extents to say why the rights of the child should be protected. And it's this mandates states. States are not just asked to do what they want. They are obligated, they are mandated. And by signing on to the CRC, Convention on the Rights of the Child, state parties have agreed that they will protect to the fullest extent possible the rights of the child. Now you now begin to wonder, where does all this issue of rights to drug users, which contradicts what state parties have covenanted to have been mandated to, where does it all begin from? Article 24 of the Child Rights also says the rights of the child to the highest attainable standard of health. 27 states that the states recognize the right of every child to a standard of living adequate to physical, mental, spiritual, and social development. Now, the rights of the illicit drug user contravenes this in every material facet. The illicit drug user, even in the family, it affects children. Because once you have an illicit drug user, you begin to now, if it's budgeting, it affects you because you don't have the budget to now devote more funds on children. So the contradiction is stark. The laws back the child. There's absolutely no law or even no morality backing these so-called rights of illicit drug users. And most important of all, Article 33 of the Convention on the Rights of the Child mandates states to protect children from all aspects of illicit drugs. I mean, people used to think that was the only one, but it flows. The children have to be protected. Compatibility of diverse, the proportionality. Now, when you look at the arguments of those who say, okay, the illicit drug user has rights, so we must allow them some rights. Human rights are not absolute. Every state has to moderate that personal liberty or personal rights to use societal benefits. Otherwise, those who say they have a right, they don't want to use the seatbelt. Are they allowed to just enjoy that right of not using seatbelts? No, the state steps in. For not even for your own rights, but for the benefit of society, so that you don't go about killing yourself and killing others. Just also like pharmaceuticals. You cannot say, okay, I want to take whatever drug I want to. No, the state regulates it. You can't say I want to just assist somebody to kill himself. No, the state regulates that. So likewise, with regards to children, the state has to come in and curb the so-called rights to use so-called right, because it's non-existent, to use illicit drugs. Again, on the compatibility issue, expanding human rights language to encompass a right to recreational intoxication risks diluting the moral force of human rights discourse and trivialize the gravity of it. When you extend this issue of human rights to the right to intoxicate yourself, you model up, you mess up the whole idea of human, and the state will now say, okay, if it has gone that poor, if it has gone that bad, then perhaps we can ditch the whole idea of human rights. So, but we must hold it sacrosanct that human rights needs to be protected, but at the same time, societal and communal interest has to be taken and has to prevail, because you are a human being, because you have a society in which you live in that protects you. The claims of a right to use illicit drugs violates the following international conventions for confidence. It's not just that you're doing what you want to do, but our state parties are doing what they want to do, but they directly violate established international law. For instance, under the Single Convention on Narcotic Drugs, states are obligated to limit drugs use to medical and scientific purposes. And at the last check, that law still exists. So when states begin to directly violate laws, what do they expect the citizenry to do? Also, Section 19.3 of the International Covenant on Civil and Political Rights provides that freedoms to be restricted public health, which allows for freedoms for the benefit of others. Your rights can be restricted if it will benefit the society. That is, under that same law, you can withhold people who have infectious diseases. You can contain them so that they don't infect others. Likewise, the right, if it ever existed, to use drugs should be curtailed for the benefit of society. It's basic, because Section 19.3 of the ICCPR allows states to curtail freedoms, individual freedoms, for the benefit of society. And Article 12 of the same of the ICESR enjoins states to take steps for the prevention, treatment, and control of disease and harmful conditions. Okay, we all agree drug is a mental health condition, so states are mandated to take steps to prevent diseases and harmful conditions. Now you begin to wonder, where does all this idea of right to use illicit drugs come from? Profit. The claims to the right to use illicit drugs directly contradicts the following. I've stated it, and also the Article 3, which urges that the best interest of the children should be the basis of all laws. The best interest of the child. Now, is it allowing somebody else to use illicit drugs? Does it in any way impede on the interest of the child? Sure. From the home to the public space to the school environment, it does. So when you sit down and look at all these facts, you now begin to wonder, why do states even get involved with, in any way, trying to promote this right to illicit drugs? The answer still remains funds. Profiteering, but do you put profits over the well-being of the child of your society? It's actually madness. The duty to prevent and neglect harmful environments. These are all the things that the right to use illicit drugs contravene. Now, where a claimed adult liberty undermines binding treaty obligations, protecting children, international law gives priority to the child protection. That's what we have clearly established. So if you claim whatever rights you think you have to poison yourself, to intoxicate yourself because you have liberty, the state is mandated under most domestic laws and under all international laws, the basic one I've set up, to ensure that the child is protected and the child is given priority in all these considerations. Thank you very much. I hope I was in time. So I'll leave it till for Gary Christopher.
So I want to just discuss the fact that illicit drug use is not victimless. And we'll just get that up so that you can see it. So there is a fundamental agreement that everybody agrees on, and illicit drug use causes, in actual fact, unacceptable harms. Doesn't matter whether you're a harm reductionist or a preventionist. That's the agreement. And if not, we would not have government-funded harm reduction programs, would we? So preventionists have a major concern that harm reductionists pretend that drugs only affect the individual user. That is not the case. There is no shadow of a doubt that they unacceptably harm the user's partner, their children's grandparents, who are often tasked with looking after them, siblings, friends, workmates, other road users, the general community. And US household survey stats for 2020 show that 27% of children are living with a caregiver who has a substance use disorder. So that means 1 in every 4 children. And US household survey stats for 2020 show that 27% figure. So let's take a look at children who are orphaned by illicit drug use alone. And you need to be looking at the trend line of the dark green colour, which is second from the top there. This is the incidence graph, and you can see that that green line is going up steeply for the year 2021. And in that year, we saw actually 1 in 840 US children lost a parent in 1 year. Okay, here's the prevalence graph, and you can see the green line going up steeply again over 20 years. And over those 20 years, 1 in every 175 US children lost a parent to overdose. So drug use is most definitely not victimless, and these are absolutely unacceptable harms. Now, let's look at the issue of neglect. Official agency stats don't disaggregate alcohol and illicit drugs. But we do know this, that 39% of neglect cases are due to substance use disorder. And that means that there is an overrepresentation of neglect. Now, there is another study that did disaggregate them, and it found that when intervention was needed for neglect and removal of a child, 90% of were for people who had hard drug use, and 60% of people who were using non-illicits like alcohol had their children removed. And when reasons for removal are compared, neglect makes up half of the cases. So this is a major issue that we're talking about. Now, this neglect is replicated the world over, of course. And we need to think about the stories that you see on the screen. And so we have that example from Hong Kong, where a child, 5 months old, was taken away because of acute dehydration. There was a case in Australia last year involving a working single mum who binged recreationally on methamphetamines on weekends. The kid was found on Sunday morning. When she crashed and went to sleep after the binge, kid was found on the street, and authorities came and got the child. She didn't awake until 2 p.m. on the Monday. That is what you call neglect. And then the largest study that you have found that illicit drug use implicated 75% of sexually exploited children cases. And so what you see is a small study, the smallest study, which is 75% in that study. They found that half of the kids were suicidal from sexual exploitation as such. Larger study showed 75%. Now, we have all the statistics that I mentioned in a document. And if you want to get onto that QR code there. You're able to go to our document. It is full of hyperlinks, which will take you through to the sources. And it deals with all of these elements, all right? So the sexually abused child, the physically abused child, the homeless child, the unintentionally injured child, the hungry child, the chronically ill child, the in utero damaged child, the educationally disadvantaged child, and the road accident victim child. And we're encouraging everybody to come this afternoon at 3 a.m. to this same venue where we are going to talk about
3 p.m.
the 3 p.m. What did I say? 3 p.m. And that will be for the Eindhoven Declaration launch. And that is urging the UN to do its job with the rights of the child. All right.
Okay, thank you. Good morning, everybody. My name is Stefan Dahlgren. I'm replacing Shane Warsko in this session. I'm the author of a few research publications on human rights and drugs, also on a number of child protection papers. I'm a former head of child protection with UNICEF. I used to work in Zambia on AIDS issues. Roxana and I will speak on the international guidelines on human rights and drug policy. The guidelines were launched at the CND in 2019, and I'm now going to explain why we're speaking about these guidelines. As per the logo on the cover, the authorship was with the non-governmental organization ICHRDP, International Center for Human Rights and Drug Policy. This NGO was well known to us since we wrote our books because we read many of their papers. But there was also the logos, which makes it more kind of serious, of 3 UN agencies on the cover: UNAIDS, WHO, and UNDP. And this year we found that the 4th logo had been added, the High Commissioner on Human Rights. The meeting today here was intended as a discussion or a debate with the authors and sponsors of these guidelines. And we therefore going to invite you afterwards to ask questions, because you might have questions on what we are saying, so we want to be transparent of that. But unfortunately, ICHRDP, they gave us an answer and they were busy with other things that they were doing. We didn't get any answer at all for 3 weeks from any of the UN agencies. And this has been a trend for over a year when searching to interview them and finding who is the responsible person who actually knows something about this inside the UN system, because it's quite serious if the whole thing is being leased out to an interest-driven organization bankrolled by billionaires. So, this meeting, in the launch of the guidelines 2019, there was no Q&A allowed. So the launch took place here at the CND meeting. And there was a panel with people from different continents in this side meeting. None of the people appear to be the author of the guidelines, and none spoke in any depth in terms of the substance of the guidelines. The main speaker was an elderly constitutional court judge from South Africa who had been sitting in the panel of that court that decided to legalize cannabis in South Africa. He mainly spoke about being a gay man in South Africa, which had nothing to do with the guidelines. I approached him after the meeting and asked him, as the highest legal person I could identify in the panel, how did the constitutional court in South Africa factor in the international legal framework, including human rights and the Convention Rights of the Child, and particularly the only article in any human rights instrument to address drugs, Article 33 in CRC, that obliges states to protect children from drugs. How did they factor that in when deciding to legalize cannabis? In what way was this protecting children and furthering their best interest? The judge looked puzzled and said, well, it's a matter of social justice, and then he left. So if even a highly ranked judge seems to be lacking bearings on international law and international human rights, then there's probably a very compelling reason to have guidelines. But then it's going to matter a lot how the guidelines are representing international law and human rights as they are written. On this background, it appears that A, the United Nations does not seem to have any in-house expertise either to vet or to draft these guidelines. B, it seems that UN has outsourced the writing and possibly all the answering on the guidelines and drug policy to this billionaire-financed conglomerate of NGOs led by ICHRP. So such an approach would be remarkable in any other policy field in terms of human rights and rule of law. It is therefore pertinent to transparently analyze these guidelines. Do these conform to international law, and specifically these guidelines purport to represent human rights? Do they comply to human rights? And with this lengthy introduction, which I apologize for, I go into the main presentation. So the main presentation, you can stay with that. I have two blanks. So the title of this presentation is Are the International Guidelines on Human Rights and Drug Policy in Conformity with Human Rights? The closer look at the guidelines say. The key question and the so-called test, because it's common law people has written this. I'm not a common law person myself, but I know it exists in common law courts that you're doing a test to show that you will apply the same rule for everything. Would the authors use the guidelines legal methodology for any other policy field and human rights issue? If not, why is it applied on drug policy? So now we can jump forward there. One more, and next one there. So how is the guideline looking like? I have a copy of them here. I can actually pass them around the table if you want to see them. The guidelines are 27 pages long. There is an introduction, there is 5 chapters, and there is 2 annexes. The chapters is about human rights principles, human rights standards, human rights of particular groups, implementation, and treaty interpretation principles. And the annexes are about criminal justice, health, and development, that word has fallen out there, and methodology. So, no, go back. Yeah. So in general, depending on what you're going to use your guideline for, but if it's for advising high-level policymakers in states, this looks pretty reasonable in terms of the general outline, save for possibly Annex 1, where the criteria for the selection of topics is not really clear. So then we go to the next slide after that. Yes, the introduction of guidelines. So there is a few quotes we have taken out. Rights-based action on drug control requires shared standards from which to begin. We couldn't agree more. The human rights standards are minimum standards, and guidelines will actually help, or should be helping, ensuring that these minimum standards are upheld. But then a little bit further down, it says something that goes against that. The guidelines respects diversity of states and the prerogative to determine the national policies, which would suggest that, well, if you want to do a national policy that goes against human rights, you're actually free to do so, which we don't agree with. And then there is an argument that the drafters were actually pursuing quite a lot when we read their papers. There remains a lack of clarity as to what human rights law requires of states in context of drug control. So when I met these drafters like 10, 15 years ago, it was a consistent argument from their side that the Convention Rights of the Child, Article 33, is unclear. So I asked them the question, which article in the CRC do you consider is clearer? Nobody could ever answer that question. And that suggests kind of a lack of fidelity towards international law, that you're using the language of human rights in order to reach a goal, and human rights is not an objective in itself. We move to the next one. Next one. Yeah, there. So now we come into section 1 in the guidelines, foundational human rights principles. So 6 principles are quoted in the guidelines: dignity, universality, non-discrimination, participation, accountability, and effective remedy. The criteria for the selection is not clarified in the guidelines, but the most obvious legislative principle for the purpose of drug policy, and which is recognized as a principle in itself, has been omitted: the best interest of the child. So basically, Article 3 in the Convention on the Rights of the Child is saying that the best interest of the child should be a primary consideration in policy making. So it means even if you do something that has seemingly nothing to do with the Convention on the Rights of the Child, you should consider the best interest of the child. And this becomes quite opaque sometimes. But if you have an article in the Convention, then of course it becomes very paramount that this is the starting point for your reflection on human rights and whatever the topic is. In this case, it is drug policy. So the central starting point for drug policy is that children be protected from any illicit use of drugs or involvement in trafficking or production. And that means then that priority has here been set in the guidelines. Adult recreational users 1, children 0. Let's go to the next slide. So we're coming to section 2A, obligation arising from human rights standards. Now, there are 9 human rights treaties. This forms the corpus of human rights globally. This is what we're talking about when we're talking about human rights. They have about, and I'm making it approximate here because I don't remember exactly, but let's say 30 operational articles each. So they have some administrative articles also. If we multiply that by 9, we get something like 250 total articles in these instruments. So of these, the guidelines have selected 13 rights and listed them, including concept that has no legal anchoring, such as harm reduction. Harm reduction is no right. It has no, it doesn't figure in any legal instrument. So it has no clear definition. The rationale for the selection of these 13 rights is not explained. Some suggest that the standards are very hard to understand in the context of the overall human rights commitment to children, like privacy, religion, cultural life, and scientific progress, which the guidelines has listed as rights that they want to have among these 13 rights. So let's do this test that they do in common law courts. Would such standards and logic apply for other child protection provisions in the CRC? Could harm reduction be the leading principle for exploitative child labor? So let's not prohibit it, let's just harm reduce it. Could right to privacy, lifestyle, religion, culture be coming before the right to protection against sexual exploitation of children in Article 34? If not, what is the reason why the guidelines is demoting the lex specialis, child protection on drugs, below arbitrarily selected lex generalis, such as, for instance, privacy? Let's go to the next slide. Yes, so the only human rights provision to talk about drugs is not here in this section of relevant articles. But it has been relegated to a more obscure place because it pops up elsewhere in the guidelines. So in summary, this section is a cherry picking of rights seemingly aimed at burying the only article to talk about drugs and human rights and to promote users' rights. So we go, then it's 14 nothings when you have put 13 rights on top of the children's rights. So I thought to give an example what this means then, because people might say, well, you know, we consider these rights very important. For those of you who, like myself, are a little bit older, you might remember the Iraq War and the 9/11 events in the United States. And there something controversial happened. The W. Bush administration's handling of the reporting following the 11th of September. There they decided that security and the right to security and the right to enhanced interrogation, I couldn't remember it, takes precedent. That was what the policy was based upon, instead of talking about what is obvious when you have these pictures on the Abu Ghraib prison, namely that obviously people are being tortured in the prison. So what should have been the special law, the prohibition against torture, became some kind of general law because they decided the right to security was precedent to that. Now, there is not even a provision on a right to security, so it was kind of a fabrication from the beginning. No, if the adult recreational users imagined rights, as been said by the previous speaker, to harm reduction or the right to take drugs takes precedence over legislated children's protection rights. Children will grow up with less protection against neglect and mistreatment. If security takes precedence over prohibition against torture, people are more likely to be tortured. So it's very important to follow the law as it has been written. We'll go to the next slide. So then we're coming to this third section, and here is suddenly where children has been shoehorned in. Section 3 concerns special interest groups of four groups: children, women, prisoners, and indigenous people. Also, the criteria for this selection is not clarified in the guidelines, because there are other conventions that talks about groups of people, human rights conventions, disabled people and migrant laborers, for instance. Why these four groups are selected is not clear. what is clear here is that children is the only group who has an article that's actually talk about drugs. So why they should be kind of lumped together with the others is a bit not really clarified. And that means also that the explicit obligation in the treaty has been demoted to a more general section, and that's going to give a certain way of interpreting the guidelines, which is going to be manifested later in the chapter about implementation of the guidelines. Okay, shall we go to the next slide? So when the guidelines are finally talking about children's rights in Article 33, then it comes out a little bit in a special way. So the guidelines section on children is 1.5 pages. In this space, the guidelines are studiously avoiding to analyze the full text and intention of CRC Article 33 to protect all children. This can be compared to how the guidelines have spent 4 pages to discuss right to health, lex generalis in section 2, or 2 pages for the women's rights, which is not talking about drugs at all, and 2 pages for indigenous people. So this is clear that the guidelines has a very strong bias to kind of push down children's rights on the bottom. And how is this passing through with High Commission of Human Rights? That's just a riddle, but seemingly nobody has read these guidelines at the Commission, Human Rights Commission. Looking again at CRC Article 33, the guidelines have here amended the text to what at first glance looks like a quote of Article 33 by adding their own text in the end, leading to misinformation aimed to defocus what CRC Article 33 actually says. The guidelines is in this section redefining the principle of best interest of the child to be a best interest of the individual. And I think if you think about it for a second, the reason we had the best interest for a child is to consider it was a particularly vulnerable group. If you suddenly make that into the best interest of the individual, then you have taken away that you have lowered the level of protection for the child. And this is what the guidelines has done. This is a remarkable standard lowering of the CRC and an obfuscation. But it doesn't stop with that. Following that, the guidelines are suggesting to substantially lower the prevention standards set out in CRC, which is by its wording a right to protection, but now it should be only a right to information. So let's do a test again. Would we faithfully implement the CRC protection articles on child labor and sexual exploitation if we replaced the right to protection with the right to information? And if we replace the best interest of the child with the best interest of the individual? Of course not. And this is the whole purpose of the guidelines, that they try to drag away this focus in a different direction. So we're coming then to what is the important thing for anyone who's a practitioner in the field. I want to have some advice now how I should implement this stuff. And as a result of the skewed legal logic in the previous chapters and the selective approach, the implementing recommendations are focusing on, drumroll, harm reduction. The non-legal concept of harm reduction is omnipresent in this section. It is suggesting to avoid cuts in funding for harm reduction, to provide resources for harm reduction, and to seek international assistance for harm reduction, and so on. Nowhere in the legislated central credo for human rights and drug policy presence, children's right to protection. There is no suggestion in this implementation recommendations on providing a drug-free society for children and how to get there. Which steps do we take? Monitoring how children are affected by friends or parents' drug use, monitoring how poor children are affected when engaged in a drug trade driven by middle and upper class recreational users in the West, etc. Predictably, the section ends with a plea for alternatives to coercive sanctioning for drug offenders, and that was of course the agenda target from the beginning. In summary, in the guidelines, children's right to protection is less important than adults' rights to do drugs. 16-0, adults versus children. I'm just going to say something short about methodology here, which is in Annex 2, and then I'm going to summarize and we're going to be finished. So, no actual legal methodology is presented in this annex. Instead, this page includes generalistic statements such as a group of experts was doing extensive legal research as a priest. There is a multi-stakeholder process. We have global experience with UNDP. We are drawing on international law, but nowhere is this boiled down to what does all these experiences stuff actually mean in terms of the methodology that you're applying here? It's not explained. So the end methodology is just that ICHRDP is stating you should trust us. And I think there's a compelling reason that you should really question that. Assessment of the guidelines. Let's see, jump forward one.
One more.
Yeah. There we have it. The good news, there are guidelines. So that's a good thing. The bad news is that the present guidelines is in no way seeking to sincerely inform about the global legal framework, including human rights, and how to implement it. Instead, it has shrunk legislative protection right in order to facilitate and normalize recreational drug use and diluted the best interest of the child to be the best interest of the individual. The guidelines needs to be stopped and substantially revised to reflect what human rights and international law is actually saying. And then the very last slide. The end question to UN agencies, because I'm okay if ICHRDP and NGOs are doing this, because you're supposed to have a discussion in society and you can front up your proposals, that's all right. But how the UN agencies has decided to put their covers on the logos on the cover of this guideline. This guide. Yeah,
Have it.
We'll finish for
yeah.
there.
Of this guideline is a mystery. And what is the name of the technical expert at these UN agencies, and most of all the High Commissioner who has vetted these guidelines? We have asked for that several times, no answer. Or have the guidelines and responses to the same been fully outsourced to ICHRDP? That is the questions that we're asking. And to answer a question that we had in the beginning, would the authors use the guidelines legal methodology for any other policy fields human rights issue? If not, why is it applied on drug policy? I think that question has been answered here. Thank you.
Okay. Let me just get the right slide up. I'll hand over to Roxana. She's a researcher for Drug Free Australia. And so over to you. I'll see if I can find the right slide here.
I'll try and be in 10 minutes so that you have questions.
I lost it. Okay, just keep going and I'll.
Good morning. Thank you for being here with us. And I will have to amend a little bit what our first speaker, Eze, suggested, that drug users do not have human rights. No, I don't agree with this. I think drug user has all the human rights provided in the 9 Human Rights Convention. What we don't find in the Human Rights Convention is the right to use drugs. So I would like to add this to clarify this, at least from my point of view. So my name is Roxana, and in the following, I will briefly present a research paper I wrote for OVOM and Drug Free Australia, which is going to be published in the upcoming days. This is addressing the 2019 International Guidelines on Human Rights and Drug Policy, focusing on the status and the purpose of this document. Firstly, I would like to touch on the context and appropriateness or usefulness of a guideline on drug problem and human rights. So, human rights and drug control regimes were both developed under the UN auspices. They are both framed by the same UN Charter articles, namely Article 1 and 55. Both regimes fall under the mandate of the same UN entities and are monitored by similarly functioning treaty bodies or quasi-judicial expert bodies. Most of the human rights and drug conventions were developed and adopted by the UN during the same period, namely the second half of the 20th century. So despite this contemporary development, the multiple intersection points of the two regimes, and the fact that the UN has a clear mandate on creating new specialized agencies for the accomplishment of the purposes set forth in Article 55, and making recommendations for the coordination of policies of such specialized agencies under the same foundational document, that some human rights conventions have specific provisions encouraging international cooperation between their treaty bodies and UN specialized agencies and entities, as is the case with the Convention on Rights of the Child, Article 45, that there have been countless opportunities along this road for coordination and for preventing and redressing most of the regrettable human rights concerns we are still seeing reported in relation with the drug control policies. And I would like to mention one such opportunity relevant in this context as we are here in Vienna, namely the commitment taken by 171 countries back in 1993 during the World Conference of Human Rights and expressed in the Vienna Declaration and Program of Action, adopted by consensus. What is remarkable about this declaration in the context of our discussion is that 33 years ago, it addressed, commit to redress and prevent all the human rights concerned. The 2019 guidelines implicitly addressed 26 years later, and which are explicitly addressed starting in 2015, 22 years later, by the Office of High Commissioner of Human Rights and few UN entities. For example, Vienna Declaration states, and I'd like to quote, "Respect for human rights and the fundamental freedoms without distinction of any kind is a fundamental rule of international human rights law. The speedy and comprehensive elimination of all forms of racist and racial discrimination, xenophobia, and related intolerance is a priority task for the international community. Governments should take effective measures to prevent and combat them. Groups, institutions, etc. are urged to intensify their efforts in cooperating and coordinating their activities against these evils." The 93 Vienna Declaration is dealing in similar terms with all the human rights issues addressed by the 2019 guidelines, several being labeled as evil or evils that all states are urged to eradicate. The state document calls for the right of the child should be a priority in the United Nations system-wide action on human rights. The declaration also called 33 years ago for increased coordination on human rights within the United Nations system in very specific terms. And finally, for the establishment of the post of High Commissioner for Human Rights, an entity specifically mandated, among others, to play an active role in removing the current obstacles and in meeting the challenges to full realization of all human rights, and in preventing the continuation of human rights violations throughout the world, and coordinate the human rights promotion and protection activity through the United Nations system. The first High Commissioner for Human Rights was appointed in 1994. This is 32 years ago. Yesterday, in a side event, the representative of the High Commissioner of Human Rights was reflective, horrified about the persistent level of racial discrimination, evil, and other human rights violations, without much reflection that this has been the mandate of the office he represents for 32 years. Despite all this, the human rights and drug control UN regimes coexisted in parallel without any coordination. The long due UN reflection on negative implication of the world drug problem or the enjoyment of human rights never came. In this context, an instrument like the guidelines has been more than necessary to redress the lack of coordination and propose a preventive framework against human rights violation, clarify the nature of two regimes and the obligation state party has in relation to the relevant ratified conventions, provide recommendation for legally coherent approaches facilitating mutual compliance with the two regimes and in full conformity with basic legal principles, and address the multiple human rights issues caused by the world of problem, as repeatedly stressed by the Human Rights Council resolutions and yearly by UN General Assembly resolutions on international cooperations against the world drug problem, as well as the human rights implications of the drug control policy. This is the context in which the International Guidelines of Human Rights and Drug Policies were published in 2019 with the logos of UN entities on its cover. Despite being another document focused only on the human rights implication of drug policy and almost exclusively focused on the people involved in a way or another with illicit drugs, the format and the need of such guidelines raise the expectations to another big bang moment for the stakeholders. However, on a closer examination, the 2019 International Guidelines of Human Rights and Drug Policy were generating more questions than providing answer, coordination, or guidance. The 2019 guidelines were presented as reference tool, provided authoritative support for legal reform and policy change, and highlight the measures states should undertake or refrain from undertaking in order to comply with their human rights obligation, while taking into account their concurrent obligation under international drug control conventions. But the 2019 guidelines came about in a substantially different way and form than other similar instruments, for example, the guiding principles of business and human rights hierarchy principles. As Stefan mentioned, the 2019 guidelines seems a cooperation between International Center on Human Rights and Drug Policy and 4 UN entities, UNAIDS, UNDP, WHO, and Office of High Commission for Human Rights. However, the confusion is already coming on the second page, containing a disclaimer in relation to the views expressed in this publication on behalf of the UN, including the above-mentioned UN entities. Also, the guidelines are presented as providing authoritative support for legal reforms and policy change. But it also states at the same time that the guidelines are not legally binding, which is obvious, and that they might gain persuasive authority over time, pending of being referenced in court cases and UN resolutions. In conclusion, with a disclaimer on behalf of the UN, with a non-disclosed authorship, and without any specific endorsement from the UN, it's difficult to understand where the 2019 guidelines authority is coming from. The 2019 guidelines also claim to be a tool for those working to ensure human rights compliance at local, national, and international level, including parliamentarian diplomats, judges, lawyers, policymakers, civil society, call them, they are all there. Considering how these guidelines were written, it will be rather difficult for most of the mentioned categories to understand where the principle, the legal standards, and the recommendation emanates from. As in the case, for example, for RAGI principle, the business principles that I just mentioned, a commentary is included under the stated principles. In the 2019 guidelines case, the standards and recommendations are issued in an axiomatic manner without any further explanation. A commentary to the guidelines was issued in 2023 with the aim to offer an expert analysis of the guidelines and to clarify the sources of the listed standards, but it came 4 years later. These sequences raise the question on how the guidelines has been implemented from 2019 to 2023 without any reference to the source of the mentioned human rights or explanation about the recommendation. It probably counting on operating in faith. It's also worth mentioning that the only explanatory element, the 2023 commentary, came with an even bigger disclaimer from the UN, locating the opinion expressed strictly with the 5 authors of the commentary. But looking at the dynamic between 2019 guidelines and 2023 commentary, one might get even more confused. And I'll give you one example, the principle of universality and interdependence of rights, stated by the guidelines under Chapter 1, Foundational Human Rights Principles, Subchapter 2, Universality and Interdependence of Rights. It's formulated in the guidelines as human rights are universal, inalienable, indivisible, interdependent, and interrelated, included in the context of drug policy, development assistance, healthcare, and criminal justice. Persons' involvement in drug-related criminality affects the enjoyment of some rights and specifically engage others. In no case, human rights are entirely forfeited. On the first reading, this all sounds fine. One would guess that the sources of this are the Universal Declaration of Human Rights and paragraph 5 of the Vienna Declaration, with the focus on the relevant issues. Surprisingly, the commentaries tell us the Universal Declaration of Human Rights is based on an understanding that human rights are grounded in the inherent dignity of the human person and therefore are universally and inalienable. And it goes explaining the paragraph as, this means that irrespective of ethnicity, gender, social or other status, or lifestyle choices, all human beings are born free and equal in dignity and rights. And it footnotes it to Universal Declaration of Human Rights, Article 1. We cannot connect the concept of lifestyle choices neither with the context that generated Universal Declaration of Human Rights, the atrocities committed during the Second World War.
Roxanne, we have like about 3 minutes to leave the hall. I think this paper will be available, will be published, because we have to leave the hall according to the rules of the UN. So we'll be leaving here in about 3 minutes. I don't know, we'll still have a follow-up of this program by 3 o'clock when we'll be launching the end-of-end declaration. The rules here is that we have to leave here by 10 o'clock, and we don't want to disobey the rules of the UN. But if there are any questions related to what will be said so far, or you can join us by 3 o'clock in this same hall for a continuation of this. And actually, when we resume, she'll be allowed to continue her paper before we do the end-of-end launch. I think that will augment the loss. I'm very sorry for that. Okay. But if there are any questions, okay.
I do have a question because it's extremely concerning that the CRC has been omitted and or ignored or treated as if it doesn't exist in the human rights guidelines. That's how I've interpreted what I've heard today anyway. What can we do about it? And obviously you can't answer that now, but I think most people would be very concerned that children's rights need to be very clear because of their dependency on their adult carers, etc.
What we can do about it is very direct. The state parties need to be informed that these guidelines do not represent the UN standard. And like she said, really, it's actually a forgery because the 3 UN agencies whose logo appeared there have all disclaimed that document in the document. I mean, so you now wonder, how did this come about? In the same guidelines, when you go through it, the UNODC, the UNDP, the 3 UN agencies whose logos appear there say this is not our, well, we don't abide by what is written there. So we have to tell the state parties, but that's what we'll be trying to do to ensure that the state parties raise up that motion at the CND, that we don't know what is contained here. It's actually a fraudulent document. We've been trying to mince around words, but that's just the reality. Sorry.
Yeah, just briefly, excellent presentation and also student, yes, because I was listening to the drafts and the lacuna.
Yes.
The way the CRC is being described or defined.
Yes.
Leaves too much gap, too much lacuna, when we say, to make it subject to interpretation in some courts. Okay. And when it's subject to interpretation, you tend to interpret based on what favors you. Okay. And also to mention that when the CRC was done, the substance abuse and all that, the definition was based only on the 1961 and 1971 convention.
Yes. No, 1988. 1988 World Convention was drafted in parallel with the 1989 CRC. Yes. So they were sitting in the same drafting room. So you basically the text of CRC Article 33 is the same as the what is it called? The opening, the preamble of the drug convention. If you compare, the text is basically identical in the two. So, and the CRC is referencing also the drug convention. So basically, the drug convention is an extension in itself of human rights. So in order to facilitate implementation of human rights, you should implement the drug convention as they're written. And that is, of course, if you're there are different types of harm reductionists. It doesn't exist like one definition. and I wrote a paper about this, that, there is one definition that it kind of fits with the international law. So, but there is another definition, and that is ICHRDP's definition, which doesn't fit with, because that's about the society should not bother if somebody wants to take drugs. It's their own choice. But the first definition is just about injecting drug use and providing certain services, and so that is not contradictory.
Okay.
But we have to back to your question.
So, I mean,
No, I think that's it, so that we can.
okay, any other questions?
Respect the timing.
Yeah. And finally, we'll be back here by 3 p.m. and then we'll continue with our presentation on the guidelines, and then we'll also do the end-to-end launch. End-to-end launch is what you can do as an individual. You sign onto it. The QR code will be available. It's available on the card that was dropped on the table. There's a card on the table where you have the QR code of the end-to-end